Yeah, you don't have to, you're not running any bills today, are you? Huh? I said, you're not running any bills today, are you? No.
Good morning, everyone. The time of the chime is getting close to 9 a.m., which means it is time for the House Commerce Committee to commence. Today is the last day of school, so I would ask, if you guys don't mind, if you would wait until after committee is over to pass around your yearbooks for signatures. I'd hate to have to take a yearbook up while we're trying to have committee today. So we should have plenty of time. So for autographing yearbooks, please wait until we are over. But in meantime, let's get this show on the road. There's been all kinds of drama, wondering what our grand finale would be. Well, here it is. Madam Clerk, would you call the roll?
Representatives Alexander, Barrett, Boyd, Burkhart, Camper, Clemens, Faison, Freeman, Garrett, Hale, Hardaway, Haston, Hazelwood, Holsclaw, Johnson, Lynn, Marsh, Moon, Powers, Sparks, Thompson, Towns, Vital, Williams, Zachary. Vice Chairman Bricken. Chairman Vaughn. Mr. Chairman, you have a quorum.
Thank you so much. Before we get started today, and in the same vein, the chairman's gifts will be received post-committee. It'd be a little bit awkward if we did that before bills came before us. Oh, yeah. The caucus chair obviously has a plot, so we'll allow that to develop today. Any other personal orders that we see? Personal orders that we see? Yes, Vice Chairman Bricken.
Thank you, Mr. Chairman. And again, I hate to take any enthusiasm away from this committee, but today in Tullahoma is a very sad day. The services for a former legislator, Judd Matheny, will be held today. And again, it's just a real sad day in Coffee County. And Judd did so much for 16 years here as a legislator. And I think for members that serve with him, they know how much he did for you. And he was just a great American, a great patriot. We just are extremely sad. And again, just maybe another moment of silence if we could for Judd and his family. Thank you, Mr. Chairman.
Thank you, sir. Representative Matheny's sister and two nieces are both constituents of mine in my district back in the District of Champions. So if you don't mind, I think a moment of silence would be appropriate. Thank you. All right. We are here to be about the people's business, and about it we shall be. We're going to start with Leader Cochran with House Bill 2479. All right, Leader Cochran, please tell, well, I believe an amendment is what you need attached.
Thank you, Mr. Chairman. Yes, drafting code 017272.
That is what I'm showing as well. Sir, you're in, let's get that amendment attached. All those in favor of attaching 17272 on to House Bill 2479, please signify by saying aye. Aye. Any opposed? No, there are none. The amendment is attached. Tell us all about your bill, sir.
Thank you, Mr. Chairman. House Bill 2479. This bill is essentially a clarifying statement in our code. And so the bill says if an issue does not fall into the bounds of federal commerce laws, so interstate commerce, it's Tennessee's purview to regulate those goods that are sourced, created, sold, and utilized here in Tennessee. So it's really just trying to make Tennessee's law clear that Tennessee oversees goods made in the state by Tennesseans for Tennesseans. And just to reference quickly the amendment we just put on there, it's actually in response to a question that Chairman Clemens had in subcommittee about, if what if the state doesn't have regulations set up for a specific good. And while I think maybe the code would have already implied that they still would have been under federal regulation, that's what that amendment does. It clarifies it. It says if there isn't a state regulation set up for something, if that product or good should fall under the appropriate federal legislation or regulation, that it will still fall under that federal, if any apply. So that's the small change the amendment made. But again, essentially just a clarifying statement on, essentially the 9th and 10th Amendment. But I'll yield to any questions. Thank you.
All right, thank you, sir. So given my concerns that, let's say that because of the way that the amendment is worded and the other language, let's say that airplane parts are manufactured in Tennessee and they're assembled in another portion of Tennessee. You're not saying that Tennessee then regulates the aviation involving that aircraft. It still falls under FAA guidelines. Is that correct?
That would be correct, Mr. Chairman. And again, also because of airspace, being federal airspace. That's
Okay,
correct.
and you could play that out with whether it be prescriptions or whether it could be firearms or anything that while they may be sourced and manufactured here, we don't say that, hey, within our boundaries, we supersede the federal government with our regulations.
Not so. I think it would depend on the product. So certainly, if it's something again that is crossing state lines, or anything that if you are receiving any of the major components of that from across state lines, that is still subject to federal regulations. The aircraft that you mentioned earlier, obviously, I think over 500 feet, that's federal airspace. So that would apply. I would imagine once a firearm crosses state lines, again, federal regulation, it would have to be something that is made with all of its primary parts here, stays here, sold here, consumed here. So this would not be an abundance of things, truthfully, but just for those limited items that the state would have the first right to regulate those, is essentially what we're saying.
All right. I think I understand, but I'll leave. I'll see if anybody else has any other questions. Well, we've got a list going here. Representative Thompson, you're recognized.
Thank you, Mr. Chairman. How does this change current law that deals with interstate commerce?
Leader?
Thank you, Chairman. I would argue that it doesn't change anything that the Constitution doesn't already clearly state in the Commerce Clause, that it is the purview of Congress, it is the purview of the federal government to regulate things that cross state lines, and it's the purview of the states to regulate things that stay within their state boundaries. So it's not necessarily saying anything about federal law. It's just clarifying in our own state law that if the federal government doesn't regulate something because it doesn't fall under that interstate commerce clause, that it falls under the state. So I think that's maybe something else important to clarify. It's not saying that something should be unregulated. It's just saying that if it doesn't fall under the purview of the federal government, which that would be interstate commerce, things that cross state lines, then it falls under the purview of the state. It's really just clarifying that. It's not trying to change federal law.
Okay.
Representative.
Thank you, Mr. Chairman. You indicated that, it's not going to cover a lot of things. I mean, it's difficult. Much of our population is pretty close to the borders of one of the other 8 states that we border, and when you're talking about buying and selling, it's hard to find everything just in Tennessee and to restrict your market just for Tennessee. So in researching this bill, do you have any estimate as to that you can quantify in one way or the other of items that would be covered under this bill?
Leader Cochran.
Sure. And so I think I think one of the prime examples, and we talked about this in subcommittee, during the pandemic, we saw we saw that a shortage of meat processors, and so you had folks you had folks wanting to process their own animals for consumption, or perhaps even for local markets. Now you can do that. You can do that now already with larger cuts, right? Like if you're getting a cow butchered into quarters or halves, you can do that, but you can't do that with prime cuts. You had to have USDA inspection, and it's because it's because our state didn't have, we didn't have our own meat inspection at that time. Since then, last year, this General Assembly actually approved that program for the state of Tennessee. So for state meat inspection, but that would be one. It allows your state to be a little bit more flexible in those situations. So when you had a shortage of USDA inspectors, which that was one of the big problems during the pandemic, the state of Tennessee could come in and say, all right, hey, our Department of Agriculture, we are going to inspect those cattle that are raised, butchered, and sold and consumed here. If you wanted to make that local market for a situation like that, we're clarifying that we have the ability to do that. So that would be one big example, would be meat inspection.
So sponsor, I can assume that whenever I go through Hickory Valley, that the sign that says Hotter Mile Sausage out in the front yard of this house, that now there is a state program that these folks, you would hope that they were participating in. Would that be that prior
Yeah.
to that, there's a higher likelihood of this being inspected now versus prior to the pandemic?
I would argue that, Mr. Chairman.
Okay,
Yes. Mhm.
thank you. Representative Thompson, you got to follow, got to finish up here?
No, thank you.
All right, thanks. Good questions. Representative Freeman.
Thank you, Chairman. And I just want to make sure and understand, because the comments have been made that if the federal government doesn't regulate, that we will. And the way I understand it is that if we don't have the ability to regulate, then we're going to defer to federal guidelines. Is that an accurate statement?
Leader Cochran.
So correct. So if it's a product, again, that would fall under federal regulation, correct. Basically, your statement is correct. If we do not have a mechanism set up to regulate a particular item, but it would still be set, it could still fall under certain federal regulations, even though it's an intrastate item, it still falls, according to the amendment we just attached, it still falls under that federal regulation.
Two more questions.
Representative Freeman.
Thank you, Chairman. And then, so who sets the guidelines for what those standards are? Do we have the department that's already set up? Does it come back before GovOps? How does that happen?
Leader Cochran.
Sure. Well, so in the first of all, it falls to us. It falls to the General Assembly. But then, so using our earlier example of meat inspection, where we set up a meat inspection program, correct? Any regulations that program sets up through our Department of Agriculture comes back to GovOps. That's right. It would work the same way as any other state agency.
Okay.
Representative Freeman.
And a statement there, and I have one more question. And you made the comment about USDA Prime, and I've always viewed that more as a marketing idea, showing that it's not a different cut. Whether it's a USD Prime inspected inspector and it gets stamped or it's not, the cut's exactly the same. It's just they have spent time to let consumers understand that that's gone through a rigorous inspection process, and that it can be trusted as a safe cut of meat. So is that, I'm making an accurate statement there, correct?
Leader Cochran.
I would have to confirm that, Representative Freeman. It's my understanding, I think right now, that if a local meat market wanted to set up and sell steaks instead of quarters of beef, I think that, and I will confirm, but I believe that would have to be USDA inspected. While I think it is part of the marketing, unless the state were to set up some program for animals in the state of Tennessee, I think, again, if you were to create your own meat market to do steaks, hamburger meat, those individual cuts, I think that would require USDA inspection, where your quarters currently do not.
Thank you.
Representative Freeman.
Yeah, thank you, Chairman. And then the comment about if we had an airplane, that's probably not a good example, but another product that we think is just going to be produced in. I didn't mean to say that like that. Sorry. I mean because it flies in the air.
I thought it was a fine example, Mr. Chairman.
I was saying myself, that's not a good example. I apologize, Chairman. Great example, sir. But if you have another product that you were saying is going to only be sold and utilized within the state boundaries, what is limiting that product to be sold in the aftermarket? I mean, are we going to then require an inspection after. And then the second piece is it gives me great pause to allow, if all the states around us, all 8 states, they have their own individual accreditation and standards that they're going by. It seems we're just going to create chaos, and we're going to have different standards at different states, and I don't know where I'm going to want to buy. The idea that we're not going to allow the federal government to manage this, that we all have a vote. We send members of Congress and senators up there that can have our voice heard and set it. We hear it every day down here that having different laws across different counties is bad because it creates chaos. And I just think this is going to create a very confusing environment for both consumers and producers. And anyway, I appreciate what you're trying to do here, but
Sure.
I'm not sure it's working.
I think I need to clarify for my own brain after that. Doesn't this bill stand us up in the void that's created when the feds are not in the space, not superseding the feds in that space?
I would, yes, that's,
Sponsor.
thank you. I would say that that's accurate because we're clearly stating that if a good is not if under the Constitution, if a good is not regulated by the federal government, that we are saying as a state, we regulate. We're not saying that it's unregulated.
Okay, so
Yeah.
that's because right now I would argue that in the case that Representative Freeman just made is that if let's say for me, much like Sarah Palin, I live within view of Mississippi. And every day I can go into that unregulated space and buy whatever I want and it would have no regulation. If in the absence of the feds doing something, I would be buying a product from somebody in Mississippi, but yet if I bought it in Tennessee, I might have a situation where it's been regulated and a standard being held to. Many times as a consumer, and I'll readily admit, I don't bother to check those things. If I want to buy hay from somebody, I buy it from them. I'm not really concerned about that.
Right.
But I don't see, from my understanding, I don't see, and I don't think that any court would allow us trying to supersede the federal government in our regulatory framework. And so that's my understanding. But again, I'm a little bit overcome with emotion today, and I may not be thinking clearly as this is our finale. Representative Freeman.
Thank you, Mr. Chairman. And I don't mean to call you wrong twice, but I think that what you just said, that's not how I read the bill. And I'd request we go out of session here from legal, because the way I read it is exact opposite, that we have the right to regulate anything, even if there is federal regulation. And the only time we defer is if we don't have the capacity to regulate that.
Could I respond to that before we go? to
Sure,
legal?
sponsor.
Thank you. And I guess just what I would say in response to that is that we're not, this bill isn't clarifying that we can supersede the federal government anywhere that the Constitution doesn't already clearly state that we have that authority. So for things that are intrastate, it would be my opinion that the Constitution is already very, very clear that the states have that authority. We are just clarifying that. So I'm not saying that we should ever supersede the federal government where the Constitution doesn't already give us that ability to do it within our own state borders. But we should not go beyond our current constitutional regulatory authority.
All right, thank you for that. And we've had a member request that we go out of session and hear from our capable legal staff. Ms. Lovin Middleton Dunn, you're up. We're out of session.
Lovin Middleton, Committee Counsel. So as I read the bill, it is saying that if a good is produced in this state and stays in this state, that federal regulation does not apply. Well, it doesn't necessarily speak directly about preemption. It does say that if something stays interstate and doesn't go interstate, that federal regulation does not apply. Because it doesn't specifically talk about certain types of goods, it's difficult to say how exactly that's going to interact with preemption. And I think it's going to be determined on a case-by-case basis, depending on the good itself, which is something a court would have to decide. But it is saying that if something remains intrastate, then that's going to be regulated by the state rather than the federal government. So that is how I would read the bill.
Was that even as amended?
As amended, if something remains intrastate, but there is no state regulation for that particular type of good, then federal regulation would still apply if there is a federal regulation. But if there is a state regulation related to that good and it remains intrastate, then I believe that this is saying that federal regulation would not apply to that type of good.
Thank you. Representative Freeman, you're working overtime today.
Thank you, Chairman. Sorry, I'll stop here in a second. How is this in violation of the Commerce Clause then, if we are superseding, preempting federal regulation?
Ms. Middleton Dunn?
So again, it would depend on the good itself. If there is a federal regulation that applies to a particular type of good and a case were brought, regarding this statute, if it passed, a court would look at whether it still has a substantial effect on interstate commerce, even if it's intrastate. So you might still run into preemption, again, just depending on what facts you're looking at.
Thank you.
Representative Garrett, see your hand up.
Thank
Question
you,
for legal?
Yes, Mr. Chairman. Thank you. Under the Commerce Clause, is it limited, in your opinion, the authority within the Commerce Clause of our U.S. Constitution, that it matters that it's just a good that's within one state? The Commerce Clause, in my opinion, applies to that good staying within a state, regardless if it ever crosses the state border. So is it your opinion, from a legal perspective, that the Commerce Clause, given a good, regardless of the good, if it stays within the state, never leaves the state, that the Commerce Clause does not apply to that particular situation?
Ms. Middleton Dunn?
Again, I think it's going to be fact specific. Sometimes you have, I think I've seen cases where they talk about not necessarily goods, but you might talk about solid waste and limiting where that solid waste can be taken, even within the state. Sometimes that can run into issues. But again, it's just difficult to say with specificity, because this isn't talking about one specific good. And it's not talking about the effect of regulating one specific good. It's just goods in general, and even goods that stay within a state. A court might find that they affect interstate commerce. So I can't really say specifically, unfortunately.
Leader Garrett.
Thank you, Mr. Chairman. I guess my concern is the wording in the amendment that says, it's the first sentence, that within the borders of this state is not subject to federal law or federal regulation. In my opinion, that directly violates and is in contradiction to the United States Commerce Clause. Since we're making something not subject to it, that I don't believe is something that the states can do as it relates to interstate, to the Commerce Clause of the U.S. Constitution, because I don't think it limits goods just because they travel within one state. So that's my concerns with the way that is worded. That says it's not subject to federal law, which in this context, that is a very hard thing to narrow when it comes to how goods are introduced to commerce inside a state and then inside various states once they cross the state. So thank you for that explanation. I still have some real concerns on the constitutionality of the first sentence of this particular piece of legislation. So thank you very much for your opinion. I appreciate that.
All righty. While we are taking a break from official proceedings and peppering our legal counsel with questions, does anyone else have any more of those? Chairman Clemens.
Sorry, I was going to do this in session, but I'll just go ahead and say it. So, Ms. Middleton, the question arises with regards to the Interstate Commerce Clause and the Dormant Commerce Clause. So let's say you've got a good or service here in the state of Tennessee that stays in the state of Tennessee. Now you've got an out-of-state good or service that's identical to that trying to be sold in the state of Tennessee. Are those goods or services not going to be treated differently in the state of Tennessee? They're going to come under different regulation. Would that not therefore violate the Dormant Commerce Clause?
Ms. Middleton Dunn.
There might be situations where that occurs, again, depending on kind of the facts. Under the Dormant Commerce Clause, one of the things that courts look at is whether the way that the state is regulating things within the state and outside of the state differently and how that impacts things. That is one of the considerations and can sometimes lead to violations of the Dormant Commerce Clause. Yes.
That was a very polite way of answering that. So that's all I have, Mr. Chairman.
We're blessed with the best in here, Chairman Clemens. We try to give customer service with a smile. Anyone else questions for our very capable legal counsel? If there's not, we're going to send this thing right back into session. Who does?
Just when we come back into session, if that's okay.
Okay, sure.
Thank you.
We're back in session. Leader Cochran.
Thank you, Mr. Chairman, and I appreciate the legal opinions and the legal debate. I wanted to add one more legal opinion, certainly not from me, but from Clarence Thomas, and so he's certainly a Supreme Court justice who has been in the majority here lately, and so he said in an opinion that the Commerce Clause empowers Congress to regulate the buying and selling of goods and services trafficked across state lines. The clause's text, structure, and history all indicate that at the time of the founding, the term commerce consisted of selling, buying, and bartering, as well as transporting for these purposes. Commerce or trade stood in contrast to productive activities like manufacturing or agriculture, so like the meat inspection we mentioned earlier. The term commerce, this is still in Clarence Thomas's words, the term commerce commonly meant trade or exchange and shipping for these purposes, not simply to those involved in the drafting and ratification processes, but to the general public viewed commerce in that same way when the Constitution was drafted. And so it would be Justice Thomas's opinion that the Commerce Clause applies to those things that cross state lines.
Thank you for that. We're going to, and Chairman, did you have your say, or you were recognized here back in session for the sponsor?
Yeah, thank you, Mr. Chairman. I appreciate it. And I think we've covered most of it. I think we've pretty much beat on the plain language of that first sentence of the amendment. I appreciate the amendment trying to address my concerns in the subcommittee. I do think it is problematic constitutionally. And I think on its best day, there is a state protectionism issue here that would run afoul of the Commerce Clause, the Dormant Commerce Clause, and we probably have a Supremacy Clause issue perhaps. But even if all that were to overcome, I think what we're looking at here is the other boogeyman, as the chairman used the term earlier, is we're looking to create a pretty massive state bureaucracy of regulation that doesn't exist currently. I think what would naturally result from this is you would have the desire to fill that void and just build an entirely new state bureaucracy to regulate anything and everything. And I don't think that's something that a majority of this committee is interested in. We talk a lot about streamlining and things of that nature. Consistency and predictability and things of that nature in the business community are very big concerns. So I appreciate the amendment again. I do appreciate the intent of the bill. I just think we're running real close to the edge on the constitutionality issues. Thank you.
Thank you, sir. Next up, we've got Chairman Zachary.
Thank you, Mr. Chairman. More just a comment. So based on this, and sponsor, you can speak to this. So I'm reading right now about the Prime Act that was just introduced in Congress on April 26th by Democrat Congressman Pingree and Republican Congressman Massey, and then had bipartisan support in the House, has been co-sponsored, and in the Senate, been co-sponsored by Tennessee Congressman Burchett, Green, among many others. And it actually is reinforcing kind of what we're talking about today, ensuring that states have the right to, well, I'm not going to go into reading this, ensuring states have the right to be able to regulate certain products and goods. It goes into restaurants, it goes into meat production, meat cuts. And the point of this, it summarizes by saying to ensure states do have the rights to provide certain regulations related to aspects of state commerce. And so, sponsor, related to the Prime Act, have you looked at that? And is it that federally they're trying to clarify and ensure what we're doing here is able to be done in each state?
Leader Cochran.
Thank you, Mr. Chairman. Chairman Zachary, I believe that's accurate. And I think it probably just speaks to the wider philosophical debate on this issue, and that it's growing, it's gaining national attention as well, where perhaps over the last several decades, we've allowed that federal regulation to grow to a point where it was never intended to grow. And I think the Prime Act is intended to address that. And so, again, we're seeing it at the state level, at the federal level, where we're trying to roll that back just a little bit and get it back to the original intention of the Constitution. So I think it speaks to the same issue.
Thank you, sponsor. Thank you, Mr. Chairman.
Thank you. Seeing no more hands on this, y'all ready to vote? I think we are. That's what we came here to do. We're going to vote now on House Bill 2479 to send it to calendar and rules as amended. All those in favor say aye. Aye. All those opposed?
No.
Well, I believe the ayes have that one. So you, sir, are off to calendar and rules.
Thank you, Chairman and Committee. I appreciate the debate. Thank you.
Where else can you get that much conversation about preemption?
It was a quality debate. Thank y'all.
This time of the morning. Now then, today I received a text from bill sponsor on House Bill 1907 that he was going to be unable to attend, but in his place, we had a substitute come in. We tapped the cagey right-hander, and I believe, who's got it? Oh, yeah. I'm sitting there looking at it. Representative Barrett is going to be carrying House Bill 1907. I got a motion and a second on the bill. Please share with us about the bill, Mr. Sponsor.
Thank you, Mr. Chairman. Like any backup quarterback, I'm just going to try not to fumble the snap here. This bill simply changes the definition of illegal alien as it relates to employers and employees in Title 50 of the code. It currently TCA 51-103 defines the term illegal alien as a person who is neither an alien lawfully admitted for permanent residence in the United States pursuant to the Federal Immigration and Naturalization Act, nor authorized to be employed by the Federal Immigration and Naturalization Act. This definition blurs the distinction between an alien with lawful immigration status and an alien who is in the country illegally, but who may nevertheless obtain a valid work permit under the Federal Immigration and Naturalization Act. This bill revises the definition of illegal alien to align with the definition set out in the Federal Immigration and Naturalization Act. And with that, I stand ready for questions.
Thank you, sir. Well, I appreciate that explanation. I read this bill several times and just said it was confusing to me. I'm glad I'm not going to say what I said, but restraint is sometimes called for, but I appreciate you bringing that up. It appears to be shuffling of words that appears to be a word shuffle. So anybody have any concerns about this? Because I appreciate us lining up with federal immigration status and on it. So I kept looking at it and scratching my head and said, well, there it is. So that's what's in front of us, folks. Anybody got concerns or questions? Concerns or questions? I've got Leader Camper and followed by Chairman Clements.
Thank you, Mr. Chairman. Mr. Chairman, I had a question with respect to corporations such as SK that's coming to West Tennessee, the battery plant that's coming, that's going to be a part of things going on in Blue Oval City. And if they bring in people legally under the statute, under the federal law, way it is now, and they come, they're training, they're doing all the things that they're supposed to be doing, and at some point it expires, and the person is in the middle of recertifying, going through the process again, would they immediately become an alien and they're here illegally? And what happens if that's the case to that person that's working there? I think this is going to have an impact on what we're doing at Blue Oval City. So that's why I'm asking this question.
Thank you,
Mr.
ma'am. I
Chairman.
think the key here, because whenever I first started looking at it and was trying to decide what my posture on it was to be, the thing that I kept reminding myself is that the key word here is not alien. There are fine folks here who enter our country legally with proper immigration status and provide services and are productive citizens within our world, and they're welcome here. I think the key issue here is the term that precedes alien in this definition, and it's illegal. That they aren't here lawfully. And so at that point in time, that's when whenever I was trying to figure things out was on this bill, was I had to keep that on the forefront of my decisions. And I'm not arguing for the bill. I'm just telling you the way that I looked at it when I was trying to figure out what my posture on this bill was going to be. But I saw your finger go back up, so you're recognized.
Well,
ma'am.
because he did say illegal alien several times. So what I'm getting at is a person come here illegally. They are legal. But at some point, if that status changes and they're in the process of going through being legal again, if you will, that day, today I'm legal, tomorrow I'm not, and I'm in the process, what happens to me if I'm working and in the process? Am I immediately something's going to happen to me? I'll be deported. That's what I'm trying to get at, because we have a lot of people here, like you said, they're welcome here, they're working here, they're doing all these things, and it may lapse for a day, let's say. So I'm trying to get at what would happen if that should happen. And I think it's going to have an impact on what's going on with SK and Blue Oval City, and could have had an impact on Volkswagen as well, with the people coming in from Germany to just on a temporary basis to address an issue going on with the company. So I'm really just trying to get to that. I get your point. Yes, they are welcome.
Yes,
yeah, I
ma'am.
got you.
And that's a valid, you have a valid question. And that's why we're going to turn this thing back over to the bill sponsor and let him address that. How about that?
Okay, thanks.
Representative Barrett.
Thank you, Chairman. And respectfully, I don't think that illegal is the issue here. The issue here is whether or not they have the ability to work in the state of Tennessee. And that's what we're addressing. That's what's currently in the code. The term illegal alien is already defined in Title 50. And so we're addressing that definition to clarify so that there is clarity in the workplace for both employer and employee as to who they can and cannot employ. So with looking to the Federal Immigration and Naturalization Act, as revised, the definition that we're trying to do in this bill clarifies that the term illegal alien, as used in Title 50, would apply only with respect to the employment of an alien, and preserves the distinction between an alien who may have an unlawful immigration status, but who may nevertheless be lawfully employed to work in the U.S. So that's the distinction. You may be here illegally, but have a federal authorization to work here. And that's why we're trying to clarify this definition to, again, provide clarity for both employer and employee.
Leader Camper, you got a follow-up?
I feel like you, Mr. Chairman. It's word shuffling. I didn't get it, but I hear you. I just wanted to get it on the record that I really feel like we could be traveling down some dangerous waters, and I think it may impact what's going on in West Tennessee. Thank you, Mr.
All
Chairman.
righty. Thank you, ma'am. Chairman Clemens.
Thank you, Mr. Chairman. And this bill is really only changing a couple of things from the current code, both of which are probably significant. We're changing the neither nor language to the colon and the or language, but significantly, I'm trying to get my head around, probably like you were, changing the language. An illegal alien means a person who is at the time of employment, to illegal alien means with respect to the employment of an alien at a particular time, an alien who is not at that time. Can you tell me what the intent of making that more complicated is and how that's different?
Mr. Substitute Sponsor.
Well, Again, Chairman, I think the intent is to clarify for purposes of, with respect to the employment of an alien at a particular time. So for an employer that has someone who may be a temporary worker or part-time or a subcontractor or something along those lines, this gives them clarity with what they are allowed or who they are allowed to engage in employment or enter into contract work with.
Chairman Clemens.
Thank you. Thank you, Mr. Chairman. I think we're making it overly complicated because the section that we're amending here is literally titled Employment of Illegal Aliens. And the intent could not be more clear because the moment that matters is at the time of employment. And that's what the current code says. But instead of just saying at the time of employment, which is when you would make that violation or non-violation, we're saying with respect to the employment of an alien rather than a person at a particular time, an alien rather than a person who is not at that time. It seems like we're making this a lot more vague than it needs to be, whereas the current code is pretty darn clear with regards to the intent of the section in which it's placed. I can't figure out why we're making it more complicated and vague for people trying to follow the law and not violate the law prohibiting the employment of illegal aliens.
Representative Barrett.
Well, Chairman, I think it's pretty self-explanatory, the difference in the definition of at the time of employment versus at any time or at a particular time. So when you're making a decision as to whether or not to hire someone at the time of employment and you're looking to the definition at that time, as Leader Camper has already identified, that status may change. So at a particular time during the employment of an illegal alien, an employer needs to be able to make a definition as to whether or not they are in a legal relationship with that person. So that's why the definition needs to be changed.
Well, thank you, Mr. Chairman. So here's just a hypothetical. So if I'm an employer and now I've just mentally decided to hire somebody, that's a particular time. I haven't hired them. That's not the time of employment. I've just decided I'm going to hire this individual to work in, let's say, my factory, whatever. Am I violating the law at that particular time as we're now defining it, or not until I actually employ that individual? Because under the current law, I don't violate the law until I employ that individual.
Mr. Sponsor.
But under this, I would, at the second my mind is made up, and I may tell Leader Camper here, I'm going to employ that individual. That's a particular time, but I haven't employed them. But now you're saying I violated the law just by deciding it rather than actually employing them. And I may change my mind between that particular time and actually employing them. So I think we're opening up people to more liability here in litigation than we may be intending. Thank you, Mr. Chairman.
Mr. Sponsor.
Well, as a lawyer, I think you're aware that intent does not, or even thought does not violate the law. And so just because you may think about punching me in the face doesn't mean that you have violated the law until you do it. So until you hire someone as an employer, you have not violated the law. So all we're doing is changing the definition so that for purposes of determining whether or not someone is legal or illegal.
What an interesting hypothetical we're dealing with here. Sure beats meat inspection, I can tell you that. All right, we've got Representative Hardaway.
Thank you, Mr. Chairman. I'm going to try to stay away from that hypothetical. It sure is attractive, though. I'd like to explore it, but I'm not.
We're not going to have any, we're having no shenanigans, Representative Hardaway, here on the last day of school. No shenanigans.
Thank you for that guidance, Mr. Chairman. I'm kind of in the same state that some of my other colleagues are. I'm trying to figure out why we're putting this into statute at all? Do we have a particular situation that has stirred this up? Has there been some type of requests from, and I'm only concerned with Tennessee businesses, corporations, in particular, our Blue Oval folk. Why are we doing this? And it seems to me to be more confusing. I thought I knew the law before I found out what was going to happen if we changed the law here. And so it's a why and the who.
Mr. Sponsor.
Well, certainly cannot get into I certainly cannot get into the head of the prime sponsor. He's not here to answer that question for you. I can only tell you as my reading and why I'm a co-sponsor on this. And that is that, again, going back to the question that Leader Camper posed, is that what happens when the status of an individual changes or an employee changes? And again, the current law says that definition of illegal alien is determined at the time of employment. This law would change it to say that definition can change during any point in time. So for instance, if someone at the time of employment is here legally with, or let's say they're an illegal alien, but they have a federal authorized purpose to be here and work, and that status changes at any particular point in time during the employment. Currently under law, the employer does not have any obligation to review or change anything or review that person's status. This would change that definition to say that illegal alien can change at any particular time if they no longer have the federal authorization to work.
Thank you for a very succinct explanation, Mr. Substitute Co-Sponsor. You just hit the nail on the head right there. Now I understand. Thank you. Representative Hardaway, follow up.
Mr. Chairman, I thought you were going to say for that very substitute teacher type of explanation, because it's still getting away from what I've learned in regular class here with my regular teachers. Because now I'm wondering, will this necessitate just a day-to-day examination of illegal aliens by employers so that they know when the status changes? If the status changes from the time of employment, then according my interpretation of the way that you're clarifying, and I put that in quotes, okay, it would hold them accountable and responsible, and they would be illegal, the employer, simply because the status of an employee changed, whether they knew about it or not.
Mr. Sponsor?
Representative, I think you're getting into other parts of the code, but for purposes of this definition, we're simply changing the definition as to when that determination should be made. And so I would respond to you with this, in that any employer that is employing illegal aliens under a federal authorization to do that should be under some obligation to monitor those employees to make sure that their status has not changed.
Mr. Chairman, can I get a lifeline from the audience here? He's got a much more effective argument than I've been able to come up with. I'm going to wrap here, but I'm not going to be able to support it because I don't see the reason for it. And the reasoning that I'm having says that it's going to cause more confusion and probably cause more red tape and legalities for businesses. And I don't think that's what we want to do. I don't think that's what you want to do. All right? So this is commerce. All right. Thank you. And thank you to my lifeline.
Yes, sir. We've got Chairman Powers.
Thank you, Mr. Chairman. And I just want to make a comment. I I know we've had some people talk about illegal and alien, and they feel uncomfortable with those two words, but under federal law, any non-U.S. citizen is an alien. U.S. Code Title 8, Section 1101-A-3, and Title 5 of the Immigration and Reform Control Act, which deals with law enforcement. There are 5 references to illegal alien, while the terms unauthorized or undocumented are never mentioned one time. So it is in federal code, and we appreciate you coming forth and bringing this forward and clarifying this one and lining it up. My understanding is with the federal law, so I appreciate you doing it. So thank you.
Representative Towns, I saw you had something to share down there, or something to
Thank you,
ask
Mr.
about.
Chairman. I do have a question. So in the event, Mr. Sponsor, that this is violated, what happens to the corporation at that point under the new scenario?
Mr. Sponsor.
Again, you'd have to get into the rest of Title 50 as it relates to the employer-employee relationship. Again, any violation of the Naturalization and Immigration Naturalization Act would be subject to law enforcement proceedings to enforce that.
Representative Towns.
So for the most part, what I'm extrapolating is that the penalties are not changing. They're the same. Okay.
Representative.
Sorry, Mr. Chairman, freshman mistake. No, Representative, no, we're not changing any of the penalties for violating.
Okay. Thank you, Mr. Chairman. Thank you, Sponsor.
Representative Alexander.
Could we go out of session and let legal further explain this, just to make sure that everybody understands what we're voting on here today, sir?
I'll be glad to. I'll be glad to. Our trusted legal counsel, Levin Middleton Dunn, you have the stage, man. But first, before we do that, we're out of session. We may be out of order too, but we're out of session.
So my understanding is that the primary change that this bill is making is that in our current definition of illegal alien for purposes of employment, it says at the time of employment, and this is changing it to with respect to the employment of an alien at a particular time. There is a specific federal statute under 8 USC section 1324A that deals with also the employment of unauthorized aliens. And I believe that this more closely mirrors that. The rest of our current statute already mirrors that, but that particular phrasing in our current statute's a little different. And this change would more align it with the federal statute as well. In terms of the effect of how people have to check things and penalties and things like that, this bill isn't making any changes to that. It's just really that one phrase and then reformatting it a little bit. But that is my understanding of what this is doing.
All right, so there you have it. We are aligning ourselves more with the standard provided in federal code, and I think I understand the fact that we used to define what an illegal alien was, what an illegal alien or who an illegal alien was all about at the time of employment. What this does is this now says, to mirror federal code, is that someone can go illegal at a particular time, not just at the time of employment. And so that's what we're dealing with here, and we're actually moving towards the federal definition as opposed to away from the federal definition. Any other questions for legal while we're out? Good question. Good call, Ms. Representative. Representative Hardaway.
Thank you, Chairman. And thank you to our legal counsel for undertaking this. When you say that it mirrors certain language in the federal code, that would suggest to me that it doesn't mirror other language in the federal code. So how is our mirroring different from the federal code that it seeks to mirror?
I believe it's merely, we are merely mirroring the definition, I believe. Is that correct? You know, and it's all time that we look at the man in the mirror. That, by the way,
Mirror, mirror on the wall.
Counselor Could you confirm that for the record?
So the definition under federal law is, the term itself is an unauthorized alien, and it means with respect to the employment of an alien at a particular time that the alien is not at that time either A, an alien lawfully admitted for permanent residence, or B, authorized to be so employed by this chapter or by the Attorney General. The two qualifying aspects of that, the A and B, our current statute mirrors, but it was just that piece about respect to the employment of an alien at a particular time. Our current statute doesn't have that exact language, and so this bill would just be lining it up with that particular phrasing.
You good, Representative Hardaway?
Well, of course not. However, I got enough to ask another question.
All righty.
So when,
And is this of the sponsor or is it still of legal?
of legal.
Okay.
I don't think the sponsor wants these, so. On the issue of the when did you know, as opposed to what did you do about it, but when did you know? Does this change our Tennessee law to hold a business accountable? Does it become an illegal business for failing to recognize that they have an illegal alien employed at any point in time? It
Counselor.
seems in my mind that under current state law, the onus is upon the business at the time of employment.
Counselor?
I don't know that I would read the current statute as necessarily specifying that it's right when they're hired. Because my understanding would be, you know, if their status were to change after they were hired, this is still something that would come into play. Again, I don't know that it's making a substantive change to, you know, the timing of when they have to figure these things out or when they learn, or anything like that.
All right, let's get somewhere quick, Representative Hardaway. We have all sorts of festivities to continue with here today.
Thank you, Mr. Chairman. I certainly enjoy being a part of them. I think that what I heard from legal is still saying that it's changing a responsibility of the business to know at all times what that status is, and there's no defense to say I didn't know. And I'm just not, and Mr. Chairman, if I'm messing up the interpretation of legal, please give her time to straighten it out. But that's my interpretation, and it causes me, if possible, even more concerns about changing current law.
All rights are duly noted. We're going to go back in session. Clark Boyd, or excuse me, Representative Chairman, the fine representative from Wilson County, Chairman Clark Boyd, you're recognized.
Thank you, Mr. Chairman. We can be casual. It's fine. Mr. Chairman, I'd like to call the question on the bill.
All righty. I see no one arguing that, sir. All those in favor of sending 1907 on to calendar and rules, it's not even amended. As written and as presented here today, all signify by saying aye. Aye. Those opposed? No. The ayes have it. Noes, please register your concerns and your vote with the clerks. Next, we have, coming before us, we have House Bill 2910 by Representative Alexander. Third. Representative Alexander, you're recognized.
Thank you, Chairman. And what this bill does is simply to ask ECD and the state to show us how broadband is being conducted across the state. We've got $800 million in grants going out, and my concern is for the state, and the reason for this bill is we just want some transparency so that we know when broadband is getting to the unserved and part of our state and getting finished and completed.
All righty. Thank you, ma'am. And for the balance of the committee, Representative Alexander and I have been in conversations about this bill, what we're trying to do, what we're trying to accomplish. We've also initialized some meetings with ECD to get a reporting mechanism. We're going to try to do this to where we can get some information put together in a format that begins. Actually, we're going to use Representative Alexander's district as kind of the test case for us to develop what this will look like going forward across the state. And I have endeavored to, basically, we all need to know more about broadband throughout the state. I think that that's critical. I think that we need some time to develop how this reporting structure and mechanism is going to work. And so that's what we're going to be working on as we go forward with regards to this, so we can help, figure it out and get a reporting program together to where people know what to expect, that we as committee members will know how to report back to our constituents what's going on in the world. And so as a result of that, we're going to be working diligently moving forward while the rest of the time in this session, and then also over the summer. But Representative Williams, you're recognized.
Thank you. Thank you, Chairman. Thank you, Representative Alexander, for this bill. I think, as you said, there's a lot of work and discussion to be done here. I do think that we're on to something. I know that this body spent $15 million trying to look at broadband and where those accessibility issues were as it relates to that in the past. And so because of that, and because of the work that the chairman's doing and the representative's doing from her district, I would make a motion to move this to summer study.
Second. We've got a motion and a second. We've got a valid motion. We've got a second. All those, well, we've got discussion on the summer study. Representative, let's see, who's next? Representative Hardaway.
Thank you, Chairman. The irony is that I was going to talk about how important this was to move as quickly as possible because of disparities and inequities that exist among the haves and have-nots when we're talking about technology, access to the internet and access to those businesses that handle commerce, to entrepreneurial activity, thanks to AI and quantum computing. I think everything that we're about now as commerce legislators is wrapped up in the data that her bill will allow us to gather, analyze, and identify the inequity, the disparities, whether we need to devote resources and when and how. The enemy right now is time. If we do a summer study, those few months that go by between now and 2025, when we're back in session, can cost our communities greatly in terms of production, in terms of employment, in terms of entrepreneurial activity. This needs to be dealt with now. I don't see how anybody can find any harm in gathering data to be studied so that we can do a better job as legislators. That's all I got to say, Mr. Chairman. I was surprised by the motion.
Well, Representative Hardaway, I think that you must not have been paying attention when I was droning on and on and on about how Representative Alexander and I were going to be spending our time here in the waning moments of this session and through the summer. We're going to be gathering data. We're going to be working with ECD. Rather than us produce a bill that directs them to produce vagaries and data that we've got, we're going to actually put something together, because I can tell you that the sponsor of this legislation is one. I don't believe there's another member who is more frustrated with the ability to figure out why broadband is not getting into her district. I will just tell you that is, she is my friend. I'm committed to helping her, and I'm committed for us learning more about this subject matter so that we can legislate more effectively moving forward. This bill was not put on hold. This study was not put on hold. It's merely taking a different path to getting this information distributed. I saw your hand return.
And Mr. Chairman, you know I trust you, but I don't trust summer studies. I've been here since 2007. I've seen how summer studies can be used in the manner in which you just described. I've also seen how summer studies can be used to dismiss a bill altogether. And I know that no matter what your best intentions are, or the members of the committee, that at the end of the day, unless we have the speaker saying, yes, we're going to have a summer study, we don't have a summer study. So I guess I'll just ask, is the speaker on board with this?
Yes, he is. He is already committed to speaking with the Commissioner of ECD for us to get access to the information that we need.
Well, Mr. Chairman, I appreciate that. If the sponsor is fine with that, I'm going with the sponsor. So thank you, Mr. Chairman.
Thank you, sir. Madam Sponsor, you're recognized.
And thank you, Representative, for your comments. And yes, I commit to you and to this committee and to my community back home and to your committees. We're going to make sure we get broadband dispersed as quickly as possible.
And Mr. Chairman,
Yes,
if
sir.
I may, I'd like to thank you for including Orange Mound in that summer study.
Understood. Representative Towns.
Mr. Chairman, thank you, and thank both of y'all. I feel a lot better when you say that the speaker is on board with it. I mean, we all know, if you can remember the time when everybody was trying to find a hot spot, Starbucks and all these other places trying to, transact business or do work in school or what have you. A lot of that has gone away today, but still we have parts of our community that's not sufficiently supplied or Wi-Fi, so to speak. And certainly we need to make sure that this occurs in short order, because if I'm looking for a job, I was talking to some people in the community the other day, they were trying to find a job and they didn't have access to the computer to where it was a hotspot to even apply. People don't walk up and knock on doors and go in hardly anymore to find jobs today. So, and I really appreciate the chair lady's, enthusiasm and emphasis on getting it done. And I want to echo that we get it done for the entire state as quickly as possible, because our people need it. And with the, the new AI and all this other technology is not going to go away. It's never going to go back to the way it was. We need to get it done. But my question, Mr. Chairman, to you is this: if we find out in the study they're not moving expeditiously enough, what do we do to them? How do we accelerate it? Is there a penalty? What happens when we get this data and it's not to our liking?
Well, that's part of what we're doing here, Representative, is there's we need to have two reporting mechanisms, one for federal dollars that don't come through ECD, and we've got another one that grants that flow through ECD, and keeping track of these dollars and how they're being dispersed in the communities and performance expectations of vendors and deliverers and receivers of these grants and what they've got to do. This is not a resource problem.
Okay.
This is not, it is one because we have had money. This is my brother, who is a little bit more affluent than I am. Sometimes when I'm out sweating my brow trying to fix something, he says, you just need to money whip it. And he said, you can pay enough money to get something done. And so that's what we have done with broadband. But our concerns is that is all we have done is we're trying to get it going, and we need to get some metrics in on performance and what real expectations are, not only for our communities, but also for this body to deal with exactly what you just said. Is what are we going to do with the data when we get it? And if we need to make changes along the way, then that's what we'll have to do. But that's the info that we're seeking at this point.
Well, thank you, Mr. Chairman. Certainly we're on board. And I think you'll find that the committee is on board to try to make sure that we implement this as quickly as we can and the best way possible. Thank you.
Yes, sir. And I will say, y'all do realize that once we started studying utilities, that we came out with a better way of dealing with some of our utilities and regulating them. This is much along that same track. Let's have a firm understanding of what's going on out there so that we can make good decisions. Representative Vital, you recognize.
Thank you, Mr. Chairman, and thank you, sponsor, for bringing this bill. I value the importance of your commitment to a summer study. I'm challenged, like so many of my fellow representatives here, when I represent a district that has some of the fastest internet broadband service in the world. Yet I have parts of my district that have no internet. And that's hard to imagine in the fourth largest county in the state of Tennessee. But it is the most expensive, that last mile, and it's like rural electrification back in the 30s. And so if we can find those pockets and we can truly identify them, how do we get the resources to them? So on behalf of the people of Birchwood and Harrison that do not have broadband, I want to work with them on this summer study, so I support it. Thank you.
Thank you, Representative Freeman.
Thank you, Chairman. And I'm out of order, but some volunteers for Voices for a Safer Tennessee have walked in. I just want to thank them for being here today and specifically call out my friend, Dr. Brian Perkinson, for being here. Good to see you. Let's make them all feel welcome. Thank you.
Welcome very much. You are very welcome here and glad to see everyone. Next on the list, Chairman Zachary.
Thank you, Mr. Chairman. Question on the motion.
A question on the motion. All those in favor of sending House Bill 2910 to summer study, please signify by saying aye. Any opposed, noes? Ayes have it. We're off to do a real summer study. Chairman Powers, for what purpose?
Thank you. I'm out of order a little bit too, but I have a couple of people here that my constituents tonight. Kent Yonts and Brian Yonts, his son. Kent is the state election commissioner. So we're just proud to have him here from my district, my county.
All
So thank
right.
y'all for coming
Welcome
out.
the Yontses to committee this morning. All right. Next on our, we're going to move over now. That completes our regular calendar. We have an addendum calendar from a bill that was referred over to us from insurance. It's House Bill 2147. Oh, wait. Item 4.
This is item 4.
This,
Yeah.
2147.
Yeah, I see that.
okay.
Yeah.
Okay. On your March calendars, this shows as item 4, but it technically, through the clerk's office, it's an addendum calendar. But what we can all rest assured is House Bill 2147 is about to be presented by Representative Hill in the stead of our comrade Representative Hale, who is. I'll just tell you what, we got to keep him in our prayers. He is struggling in his recuperation from that formaldehyde poisoning at his business, and so I spoke to him last night on the floor, and he is struggling. So let's remember him in our prayers. But we're glad to see you today, Representative Hill. Could you share with us about this bill?
Thank you, Chairman and committee. I've got amendment 017362.
That amendment has already been added through the insurance point, so we'll just hear you as amended, sir.
Okay, thank you, Chairman. This bill, House Bill 2147, establishes 2 new additional means of obtaining wheelchair repairs. One allows independent repair persons to make some type of simple non-clinical repairs without voiding the chair's warranty. The second is through an annual preventative maintenance visit conducted by a wheelchair supplier. And with that explanation, pending any easy questions, Mr. Chairman, I seek passage.
Thank you. Thank you. We've got a question on the bill. Representative Towns, I would hope you would sign on to this bill. This was the bill we referenced when you brought your bill forward earlier. And so we'll come back to you as soon as we've had a question on the bill, sir. All those in favor, please signify by saying aye. Aye. Any opposed, no. The ayes have it. Representative Towns, you're recognized.
Mr. Chairman, thank you for the reminder, because I talked to Representative Hill about that, and gladly and gleefully gave it up to him to make sure we were absolutely accurate in what needed to be done. And certainly, I want to sign on to the bill, and our prayers go out to to Brother Hale.
Representative Hill, you're off to calendar and rules, your next stop. Thank you for having us. Okay, so with this, we have a special calendar item, House Bill 1276 by Chairman Boyd.
Second.
Chairman Boyd, you're recognized.
Thank you, Mr. Chairman. Chairman, I'd like to take this bill off notice, please.
Oh, we certainly don't mind that.
Return to the clerk's desk.
We're going to
brother.
send that one back to the clerk's desk. And so with that, ladies and gentlemen, we have completed our calendar move to the clerk's desk. For those of you here today, I want to point out something. I'll recognize you in just a second there, Chairman Clemens, but I want to recognize a couple of people here today. I want to recognize Representative John Holsclaw and Deputy Speaker Curtis Johnson, who will not be returning in our midst. I tell people all the time, I am blessed, and I'm getting there. I am blessed to serve as your chairman, and I tell people all the time, I am fortunate to serve with the best committee members of the entire General Assembly. I enjoy working with you people. You challenge me intellectually. We enjoy spirited debate in here, but we do not enjoy mean-spirited debate. We hammer on issues, and I appreciate that very much. Representative Thompson, who comes from my neck of the woods, this is also his last committee meeting. But one of the things I want to touch on is, and more so than with Representative Thompson, I know him through the Shelby County delegation, but you know, when we all come in here, you remember the people who were nice to you first. We really do. And these two guys took me in and mentored me. I hate when I'm sincere. When I'm sincere, I typically get emotional, but hey, well, that's, you're seeing the efforts. I don't know whether it did or not, but the one thing that they have taught me is that you can enjoy yourself, but you need to be prepared. And the work that you do is still important, and you know how to conduct yourself as a gentleman and how you carry yourself among your peers. And I think that's going to be one of the things that I miss the most about my friends not being here next year. And so anyway, I just want to salute these guys, all three of them, for being great members of our committee. Yeah. You know who else is great in here? Ava and Anna. And substituting today, Alora has been added to the team. There are clerks who serve us so well in here. They call everyone's name every committee meeting. That they do really, really good work there. Also serving us, she worked overtime today. Miss Lovin Middleton Dunn, who's our legal assistant. Jackson Stubblefield is our clerk. He's the one that's constantly going, no, you got to do this. You need to do this. My talented assistant who over here, Miss Rachel Bennett, she is a young lady who is going to go far in this world, and I'm so proud of her, and she's really good at her job. And I see Mr. Rubin down there. If you'll notice, there's not been one single altercation in this committee room this year. And that's because that gentleman down there has a very kind yet menacing demeanor about him. There's no monkey business going on in here. He no shenanigans. We are all business, and it's because our Sergeant at Arms sets the tones for us. So anyway, again, my highest honor and the funnest thing I get to do here is be the chairman of this committee. And so anyway, I want to thank the speaker for that honor. And with that, we were about to adjourn. All right. I'll calm down. Hopefully there's some gifts involved. Chairman Clemens, you're recognized.
Thank you, Mr. Chairman, and I really appreciate your remarks, and I share your sentiments about the individuals who are retiring, all great public servants. And I also want to point out that our Sergeant at Arms is the best dressed man in the room. That's his other claim to fame, other than keeping the fights from breaking out in here. But I just want to take this opportunity, of course, to recognize my caucus member, Representative Dwayne Thompson from Shelby County, as you already did. He came in from day one, set the tone to represent the people of his district, and has done an amazing job. I know my caucus, I speak on behalf of all of us, we are going to miss him, his sage counsel, his calm demeanor, his wisdom, and he's leaving us. He's probably the smartest one of the group, like the others. He's leaving us to go spend more time with his grandchildren. And I think we all have our priorities straight, and he certainly has his in line. And I just want to say, Representative Thompson, on behalf of the Democratic caucus, thank you so much for your long term, not just in this General Assembly, but to the state party, to the Shelby County, and to everybody you have served and benefited throughout your public service, sir. Thank you very much. If we can all show him a little. And now, part two. Mr. Chairman. You know, I just want to thank you for giving us a fair opportunity to speak in here. I know being chairman is a tough job. And I don't know what you did to the speaker, but he gives you a committee with me, GA, and Joe Towns all in the same committee. And Mike Sparks on top of that. But you have managed to hold this thing together despite us. And I just want to applaud you for that. And I will just say, it takes a big man to run a committee like this. And speaking of big, I've got a present for you for your great service as our chairman. I know a lot of jokes have been made, but I didn't want to add fuel to the fire. But I just thought this was the most fitting, since you're the sheriff of this committee. You needed a hat that fits the size of you.
Unfortunately, it may not be big enough.
And I will just let you know, since this is a pot and kettle thing, I bought one for myself as well. So we'll have to get a picture of those together. But I seriously, in all seriousness, thank you for your leadership of this committee. Thank you for letting us speak our mind. This is always one of my favorite committees. It's an honor to serve on it with all these individuals for whom I have a great deal of respect. We discuss serious issues in here that matter to the people of Tennessee. And we do so thoughtfully. And I appreciate everybody else on this committee as well, on both sides of the aisle. You guys are doing amazing work for the people. And thank you, Mr. Chairman. I appreciate you.
Thank you. I'm afraid, Chairman Clemens, that you fell for the advertising that one size fits all. I think that it's more along the lines of one size fits most, and some of us are not in the most. All righty, that's a good day. Yes, sir, Representative Towns.
Mr. Chairman, you know, serving as a senior member on the committee, I have seen a lot in my tenure here. And I think that obviously we're afraid to see good men like Thompson, Holtzclaw, and Johnson go, because you never know what's coming behind them. Okay. And to each and every one of you guys, hey, that's a true statement, guys. You never know. The old folks say you don't miss your water until your well runs dry. Okay. And Lord knows we need water. But, you know, they have always done just a fantastic job. And I've gotten personally to know each and every one of them. And as so typically has been said, you'll be missed. All of y'all will be missed in this committee. But you've done your debt, your duty to the state and to the people, and you've done the best you can. And in every life, there's a transition. There's a different season that happens. And y'all have met that season. And you're transitioning to some other things, which we know you'll be great at. And you'll always have friends down here, as long as I'm down here, to be able to assist you along the way. Mr. Chairman, with you as well, one thing I'll say about you, you're always prepared, and you have great knowledge of business and insight. Along with that, as the chairman said, you allow us to debate back and forth, which is really good for the people I think it's a model that many of us need to take after. And you've done yourself well. And I love your sense of humor. You can give it and you can take the jokes too. You've been just a good man helping us to trot through these kinds of issues and make them seem as easy as they seem, but they're not, because they're complicated issues that you have to labor and study over. And you've done that. So, Mr. Chairman, for that, we're indebted to you as well. Thank you very much.
Thank you for the kind words. It is my honor to serve in this role, and if there's anything I can do to keep campaigning to be able to stay here, I will always do that. All right, folks, let's close her down. Good thing we didn't wreck the car. Without objection, we are now adjourned to the subject to the call of the chairman. Yeah, I was glad to have you back.